There's a civil trial that's happening right now. And before we talk about it, I want to talk about the Petito versus the Landries. Now, when it comes to Petito versus Landry's civil trial, this is what I'm seeing a lot of. I'm seeing a lot of sympathy towards Gabby Petito's family. I'm seeing a lot of hate towards Brian Laundrie's family. You know, a lot of them are calling them callous, unsympathetic for their actions or maybe lack of actions when people were searching for Gabby Petito. Some believe that his parents are also responsible for what Brian did. But here's what I'm also reading. Petito's family greedy. Petito's not going to get any closure from this. Brian's family should be punished for Brian's murder. They didn't have a duty to help Gabby's family. And it's possible if you're just looking at this case at a glance that you might agree to some of these points that I just mentioned. But you know, it's a very complicated yet very intriguing case. I want to refer back to the June 2022 judge ruling on why this case is continuing on to trial. But before I do want to address something. Gabby's family did settle in the wrongful death lawsuit against the estate of Brian Laundrie. So some of you guys may be thinking, well, why is there still this lawsuit? Well, this is a civil lawsuit, and in civil lawsuits, you can file multiple ones. In this scenario, there's a wrongful death lawsuit, and then there's an emotional distress case as well. It's no doubt that Brian murdered Gabby. He even wrote this in his suicide note. However, many of us are very skeptical about his version of events. If you guys don't remember, he wrote that Gabby and him were out camping, and she was severely injured. It was freezing cold, and, you know, just to be a noble person, he decided to give her a peaceful death by strangling her to death. Now, remember, the FBI, they released reports saying that, like, hey, the manner of death in which Gabby had suffered was blunt force trauma to the head, blunt force trauma to the neck, and manual strangulation. We even went over in a video, I think I posted this like a couple months back, of how far Gabby and Brian were from their van and that he could have just simply gotten help, called for someone, or, you know, I think people even said there's cell reception out there. So yeah, we're pretty skeptical about his version of events. But anyways, going back to the wrongful death lawsuit, did Brian Laundrie have $3 million? No. The $3 million, it has been said that it was just an arbitrary number that they chose. But even so, let's say that he did have $3 million. Well, it's not like the money was going to go straight into the pockets of Gabby's family. It was going to go towards a foundation that they created in honor for her, the Gabby Petito Foundation, which goes to helping victims of domestic violence and also helping organizations find missing people. So that to me is going to dispute the claim of people saying, well, they're just doing it for the money. No, I don't think so. Now, going back to the emotional distress claim, how could a family not aiding law enforcement and not helping Gabby's family lead to a lawsuit? Similarly, how does a lawyer's public statement lead to a lawsuit? And this is where I'm going to refer to the judge's ruling in June of 2022. The Landries have tried to have this case dismissed, but in June of 2022, the judge was like, nope, we're denying that. So let's go over that really quick. Now, we did cover this almost about maybe like a year ago, but because it's been so long, I think it's worth just talking about it again, especially since we have the live stream hearing happening right now. So this is what the judge wrote. 1, a note about legal duty. So again, remember, there's legal duty, there's moral duty, right? So a lot of people are leaning towards moral duty. It was like, whoa, you know what? Landry family, you guys have a moral duty to tell the Petitos about what happened. You know, if you knew what Brian did, if you know where Brian put the body, if you knew that Brian's hiding, let us know. However, there's difference between moral duty and legal duty, right? So we're going to talk about the legal duty right here. Now, laying aside the moment, the statement that Landry's made through their attorney, the other conduct plaintiffs complain of mostly involves the Landry's failing to act. Specifically, plaintiffs seek to fault the Landrys for not telling the plaintiffs that Gabby was dead or where her body was located. The Landrys framed their silence in constitutional terms, arguing that their silence was constitutional permissible under the First Amendment, Fifth, and Sixth Amendment. So first being freedom of speech, fifth being right to not discriminate against yourself. Sixth Amendment is right to a public trial, right to a jury, right to know who your accusers are, right to obtain a lawyer, to the U.S. Constitution and the related Florida Constitution provisions. The court does not believe it is necessary or appropriate in this case to resolve these constitutional claims on a motion to dismiss. The contours of the facts are not sufficiently distilled to apply those important guarantees. These claims are more appropriately addressed, if at all, at the summary judgment stage. Plaintiffs, during the oral agreement, candidly conceded they struggled with the legal duty owed by the Landrys to them that would be required to have the Landrys break their silence. Plaintiffs appear to conflate morality with legal duty. Plaintiffs have not identified, and the court is unaware of any legal duty the Landrys would have owed to the plaintiffs to tell the plaintiffs that Gabby was dead or the location of her body. And that's very important right there. Further, the plaintiffs point to no duty that the Landries were under to accept text or social media messages from plaintiffs or refrain from taking vacation while the plaintiffs search for Gabby. So just remember, the Petito Schmidt family, they try to reach out to the Landries. They tried messaging them on Facebook, maybe even tried calling them, and they were blocked. And so in addition to that, to really add salt to injury, they also took a family vacation. And so the court is saying here, like, hey, you know what? Like legally, they didn't do anything wrong. Okay. It's okay that they wanted to stay silent. It's okay that they want to take vacation. And it's okay that they blocked Gabby's family on social media, phone calls, whatever it is. Now, this is where it comes in. If the facts of this case were truly about silence with no affirmative act by the Landries, the court would have resolved this case in the Landry's favor on the concept of legal duty, or more precisely, the lack of any legal duty for the Landrys to act. Had the Landrys truly stayed silent, the court would have granted the motion dismissed in the Landrys' favor. But they did not stay silent. So the court is basically saying, hey, you know what? If the Landrys want to stay silent, that's fine with us. However, they didn't stay silent because you guys remember what they did? There was a press statement that was released by their lawyer. And this is why this whole thing is happening, because of this press statement. The press statement, they're going to go into it right now. So, 2, the Landry spoke. The Landry's attorney released a statement that plaintiffs argue was outrageous under the facts of this case. Plaintiffs sufficiently alleged that the Landry spoke. Christopher Landry and Roberta Landry, through their lawyer, issued the following statement. At an oral argument, the Landrys contended that there was no allegation in the amended complaint that their attorney knew that Gabby was dead or the whereabouts of her body when he released the Landry statement. That position is meritless for at least 3 reasons. First, generally, an attorney serves as an agent for his client. The attorney's acts are the acts of the principal, the client. Second, all facts and reasonable inferences are construed in favor of the non-movement, here the plaintiffs. A reasonable inference is that the attorney knew the same information the Landrys knew. Third, the words used in the statement indicated the Landrys agreed to it. It provided our understanding, in quotations mark, and in quotations mark, on behalf, I don't know why it's highlighting funny. Why is it highlighting like this? On behalf of the Landry family, it is our hope, ... end quotation. Certainly, there's no allegation in the amended complaint that the Landrys disavowed the statement. For purposes of the motion dismissed, the court must assume that the Landrys are responsible for authoring the September 14, 2021 statement issued by their attorney. I do want to mention that this is back in June of 2022. At this point, the only defendants were the Landrys, right? Roberta and, what was the dad's name again? Roberta and whatever the dad's name was. But now they have added that lawyer, Steve Bertolino, I think is his name. He has been added to the lawsuit now. All right, number 3, the statement. The Landrys contend that their statement is not outrageous as a matter of law. At oral argument, they suggested it was merely a plain statement. Plaintiffs, in contrast, countered during oral argument that the statement knowingly was false, designed to create false hope, and issued by the Landrys, who knew Gabby was dead and where her body was located. So the Landrys were like, it's just a plain statement. Why are we getting in trouble for this? But the Petito and the Schmidt family are like, well, you guys said this statement because how could you say this statement? You guys knew it was false. You knew that Gabby wasn't going to ever be recovered. You knew she was dead. You knew she was buried somewhere. That's what they're alleging. The elements of the intentional infliction of emotional distress tort and the contours of this tort has been described by the Second District Court of Appeals as below. I'm not going to read that entire thing, but I do want to go to this part right here. The court focuses on the second element, outrageous conduct. Let's go over the timeline really quickly because it has been almost 2 years since this happened. We're going to rewind back to 2021. So July 2nd is when Gabby and Brian decide to embark on this cross-country road trip in their van that Gabby had got. She wanted to be a van life influencer. She wanted to post her journey on YouTube, TikTok, and other social media sites. Now, August 12th, which is roughly a month later, that's where we see the infamous body cam of Gabby crying, and then Brian was there as well. The police officer got a domestic violence call where the 911 caller said the gentleman was slapping the girl. Then we stopped. They ran up and down the sidewalk. He proceeded to hit her, hopped in the car, and they drove off. Now, I do want to mention this body cam footage. the officer did ask about whether or not Brian had hit Gabby, and Gabby did mention that, like, oh, I guess so, but I did hit him first or something like that. August 27 is where there's a couple that allege seeing Gabby and Brian fighting at a Tex-Mex restaurant. They said that Petito was in tears and that Brian appeared really angry and hostile towards the staff. A couple hours after that, we do have a Whole Foods surveillance footage of Gabby and Brian at the Whole Foods, and this will be the last footage that we do see Gabby alive. Now, the day afterwards, August 28, allegedly, that's what the family is alleging, the Petito Schmidt family. They're alleging that Brian had told the family what he did to Gabby, and that is when the family decided to speak to the lawyer, Steve Bertolino. A couple days after that, September 1st, Brian returned home alone in Gabby's van without Gabby. September 2nd, Laundrie family, they retained Steve Bertolino. Interestingly, a couple days after that, September 6th, September 7th, the Laundrie family decides to go on a family vacation 75 miles away, decided to go on a camping trip. A couple days after that, September 11th, the Petito Schmidt family, they report Gabby missing in New York. And the day after that is when the FBI decided to open their investigation. And the day after that, September 13th, is when Brian decides to vanish. Now, this is where we get to the statement. September 14 is when the Laundrie family decides to make a statement through their lawyer. And what it says is that it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. On September either 14th or 15th, they found Brian's Ford Mustang around a Carlton Reserve. There's like a park out there, but they weren't able to find Brian. A couple days after that, September 16 is where the Petito Schmidt family, they're publicly begging the Laundrie family for help. And this is what they wrote. Please, if you or your family have any decency left, please tell us where Gabby's located. Tell us if we're looking in the right place. All we want is for Gabby to come home. Please help us make that happen. Petito's family reached out to Landry's family early in the month for information on Petito's whereabouts, but his family refused to answer. We haven't been able to sleep or eat, and our lives are falling apart. The day afterwards, Laundrie family, they report Brian missing after law enforcement conducted a welfare check at their house. Now, this is where the Laundrie family is like, well, we haven't seen Brian for a couple of days. It's been since the 14th that we've seen him. September 18 is where law enforcement goes search the park where they think Brian's at. September 19 is where they finally find Gabby's body. They found that she had blunt force injuries to the head, neck, there was manual strangulation, and the manner of death was homicide. About roughly a month after that, that's where they finally find Brian's body. He had a backpack, he had a notebook that has suicide confession note in there, and a revolver, which he had used to commit suicide. Now that's the timeline, so let's go back to the court doc really quick. The words used by the Laundries on the surface initially do not suggest outrage, in quotations mark. On behalf of the Laundrie family, it is hoped that the search for Miss Petito is successful and that Miss Petito is reunited with her family. When juxtaposed with the other conduct in this case, though, the outrageous threshold is surpassed. As alleged by the plaintiffs, the Laundries made their statement knowing that Gabby was dead, knowing the location of her body, and knowing that her parents were frantically looking for her. If this is true, then the Laundrie statement was particularly callous and cruel, and it is sufficiently outrageous to state claims for intentional infliction of emotional distress. The court identifies two other additional cases that support the court's decision, although neither were necessary for the court to conclude the amended complaint stated cause of action. So here are two different ones that they're going to cite, and actually I think they're kind of interesting to talk about. In Thomas v. Hospital Board of Directors of Lee County, medical personnel agreed to tell family of a decedent that the decedent died from stress of surgery and not by negligent overdose of a drug during surgery. Jesus. During the funeral, the medical examiner learned of the cover-up. Oh, thank God for the medical examiner. Prompting the medical examiner to demand the return of the body for a complete autopsy. The second district concluded that the defendant's actions of providing false information to family members under the circumstances met the standard for the claim of outrage. Good. Second case, Williams v. City of Mineola? Where's that? Police officers took photographs and a video during an autopsy and then displayed those images to non-department personnel at a party. What? Wait, what? I have to look up this case. The family members of the decedent were not present. Jeez, okay, I've heard of obviously the one with Kobe Bryant, where Vanessa and her family, they won that, thank goodness. And there was this one about a oh God. Was it a teenager who was under the influence and she took her dad's Porsche and crashed, and the crime scene was so bad that people took pictures of it and it ended up on the internet. Can you imagine the family members seeing that? It's all over the place. That's just so gross. But anyways, Jesus, is this? I need to look up this case. The family members of the decedents were not present, and it was at a party too. The 5th District concluded that even though those images were public record, the manner of display without public record request, even when the family members were not present, was sufficient to state a cause of action for intentional infliction of emotional distress. Yikes. So the Landries are arguing that, hey, court, if you guys rule in favor of the Petito Schmidt family, well, this is going to cause an avalanche of litigation. Look at how many other people are probably going to get in trouble for this. And so the court is like, nah, it's not the same thing. And I do want to read it because I do like the, I don't know, it seems very snarky, but I like reading it. Okay, the Landries argued denying the motion to dismiss will result in an avalanche of litigation. For situations where relatives of tort victims receive bad news about family members, they base their arguments on MM versus MPS. The Landry's argument misses the mark. Oh man, this reminds me of reading like all the filings that Ben Chu wrote. In MM, the tortfeasor, what's a tortfeasor? Hold on a second. A tortfeasor is a person or company that does something wrong, inflicting a loss on a third party. Tortfeasor. Okay, a tortfeasor. Tortfeasor told the parents of a victim that the tortfeasor had SA'd their daughter, and the tortfeasor's wife had supplied illegal drugs to their daughter. What? Okay. The parents sued the tortfeasor based solely on their distress from the tortfeasor's disclosure to them. The daughter separately sued the tortfeasor based on the tortfeasor's SA. The 3rd District held the parents had no cause of action under those facts. The court remarked that receiving bad news about a family member was insufficient for a claim where there is no attendant intentional or reckless conduct directed towards them. The court has no quarrel with that holding, and in fact, it is consistent with the court's decision today. Boom. The facts of MM are distinguishable because there are no facts in MM suggesting the tortfeasor directed any conduct towards the parents. Here, plaintiffs allege that the Landries issued a public statement of false hope knowing Gabby was dead and the location of her body while Gabby's parents were frantically searching for her under mysterious circumstances. The two factual scenarios are readily distinguishable. There would be no avalanche of litigation based on denying the Landries' motion to dismiss. A parting thought. The court is aware the Landries have made additional arguments that are filing an oral argument to support their motion. The court need not detail these except to say none are sufficient to preclude the court at the motion to dismiss stage from concluding that the amendment complaint states causes of action for intentional infliction of emotional distress. The Landries' motion to dismiss is due to be denied. It is therefore ordered, All right, we have some other stuff. Okay. All right. So I just wanted to talk about this before we watch the live stream of the civil case that's happening right now.